Welcome to the NACDL Engage and Exchange video discussion series, everyone. I'm Jonna Carey, NACDL Resource Counsel, one half of the resource team, along with Senior Resource Counsel Vanessa Antone. This series is typically an NACDL membership benefit made possible by the NACDL Foundation for Criminal Justice and hosted by NACDL member Mark Satawa. Today's discussion, though, is a little bit different, as does our third and final discussion in collaboration with the National College for DUI Defense, and it's open to NACDL members, NCDD members, and the public. This has been an awesome three-part series, and we are so excited for today's discussion, in which 4 teams of NCDD Regents will discuss how to analyze and prepare the defense for your submitted fact patterns. Moderating today's discussion is Steve Oberman. Steve is the managing partner of the Oberman and Rice law firm practicing criminal defense in Knoxville, Tennessee. Before we get started, I want to keep introduction brief because we have a lot to get through, but just a few housekeeping items. We encourage you to ask questions through the chat. You can use the hand raising function. We remind you that this is being recorded for later viewing on the NACDL Resource Center. Please stay muted unless you're posing a question so that we can prevent any feedback or echoing. And I'll go on and turn it over to Steve. So thank you, Steve.
Well, thank you very much for having us. We had received some requests from multiple people asking for some input from those who are leaders in DUI defense across the country. And one of those great leaders is Doug Murphy, who is the current dean for the National College for DUI Defense. I'll introduce him more in just a moment. But what we would like to do, we have, just to give you an idea of what's going on, we have 4 different problems that have been selected and 4 different teams. So each team has analyzed a problem. As they start, they will recite a summary of the facts of the case, identify the issues, discuss their analysis, and offer some hints on how to best defend the case. So I'm going to start now and let Doug take it from here and introduce us to the National College for DUI Defense as well as his team members. Doug?
Okay, Steve, thank you very much. It's an honor on behalf of the National College for DUI Defense, along with the National Association of Criminal Defense. The problem we're going to tackle is going to be with myself and also with Don Ramsell from Chicago and Belle Island for Nebraska. So I want to briefly give you some recitation of the facts here, and then we'll discuss the issues, and then we'll divide and conquer. The first case we have is a stop for failing to maintain a single lane of traffic on August 19, 2019 at around 2:58 a.m. The officer that the defendant traveled over the double yellow line and white guidelines coming around a curve. The officer activated lights, pulled over timely and safely. The officer noted only red, watery eyes and the odor of alcoholic beverage. There was no notation of any slurred speech. The officer asked for insurance and driver's license, and insurance and registration were provided. At that point in time, the officer went through the standardized field sobriety test. There were body cams that were utilized, however, they had not been produced. There was a scene video that has the audio and video are not synchronized. The dash cam did record the HGN, the walk and turn, and the one-leg stand. At the conclusion of the HGN, there were 6 out of 6. On the walk and turn, there were 6 out of 8. On the one-leg stand, there were technically 0 clues. However, at the 30th second, the officer observed 2 clues of dropping the foot and using arms. At the conclusion of the one-leg stand, there was a statement where the officer went back to the defendant and said, "How much did you really have?" And the defendant said, "I really don't want to answer that." At that point, he was arrested. There was a consensual blood draw 1 hour and 2 minutes after the stop. The blood was collected, and then 5 days later, on the 24th, was received in the crime lab, and then it was analyzed almost 1 month later from the date it was collected. The blood came back at a 0.15. For some reason, there was a second test. It appears to be a clinical enzyme test. It was not identified. I don't know who did the second test or why it was done, but it was done on April 22nd, 2019, about 8 months after the blood was collected. That what appears to be an enzymatic test is a 0.139. I want to identify the issues here, and then we can get into the discussion. Number one is we would challenge the stop. Just asked Steve Oberman from the great state of Tennessee about good case law, but unfortunately, I've been told that the Supreme Court had just shot that down. But in any other state, in Texas specifically, and also in New Jersey, it was just pointed out, I would challenge the stop. This is a one-time crossing the center stripe around a curve, and case law around the country is described as driving as a controlled weave, and one time leaving out of a lane is not indicative of intoxication. So first issue would be challenging a stop. The second issue would be challenging the field sobriety test. Specifically in this case, we had an HGN test that was done too quickly. With regard to the walk-in turn, there were a number of clues noted. However, the performance on the video actually looks very good. I don't like to refer to these clues as clues. I like to refer to them as demerits because they only penalize people for what they do wrong. They are never given credit for what they do right. And as it pertains to the one leg stand, the person actually passed, even though it's not a pass-fail, but you always call it a passing when they're doing well. But there's no clues until the conclusion of the 30-second time test. And the original research indicates that people will have difficulty doing this for longer than 25 seconds. As it pertains to the statement at the conclusion of the field sobriety test, it could be argued that the officer had already formed probable cause. And so it was nothing that that person could have said or could have done that would have undone the officer's decision on probable cause. And therefore, that statement would require Miranda warnings. And going a step further in Texas would also require audio and video recordings of that statement. And so we would move to suppress that statement based upon violation of Miranda. As it pertains to the body cams, the body cams weren't produced, but there was a dash cam. There, depending upon every state's law, there's a number of ways to obtain those, whether it's one, through your discovery statute, number two, through a Public Information Act or open records request, three, with a subpoena ducis tecum, or four, just going to the court and moving to show good cause that the body cams contain potentially exculpatory evidence, and you'd be entitled to those. The blood draw video does show a normal gait when walking in and out of the blood room. These are good normal use of mental and physical faculties. You have a delay. You also have no extrapolation factors of when the drinking occurred. If Tennessee is a time of driving or a time of test state, I'm not certain at this point. But for purposes of this discussion, you would challenge that in many other states. We do have, as it pertains to the blood, there are a number of ways to attack blood. And the two attacks that I would make on the blood analysis here is, one is the blood sample has been compromised because it took 5 days to get to the lab. I would challenge the chain of custody. We don't know what's happened with it. And then we have a delay in testing about a month later, which is probably fairly normal across the country. It is certainly in my neck of the woods. And then we have an issue of the analysis. And Belle, Don, want to open the floor to you all?
Sure. I'll go ahead and talk about it just briefly. As Doug was saying, one of the things I think that's hard when dealing with these problems sometimes is that you get facts, and you only get the facts from the perspective of the law enforcement officer. And I find it's so critical that after we talk to our client, that gives us our hook. That gives us a reason, because honestly, I found more often than not, all the science, all the training, all the challenges to the blood test, that's great for us. but it's only good for us to find the hook that we can connect with the jury and why they can then say, you know what, we're going to disregard this. We're going to throw it out. We're going to treat it as trash. And a lot of times our clients will give us that insight. So that's just one of my struggles with some of these neutral fact patterns. But as Doug was saying, there's a lot of problems with the field issues from at least the in-car, the dash cam. And what I find too is set up officers a lot of times about being fair. They talk about that a lot, that they want to be fair, that they want to give your client a fair shot and they want to do things fairly. And yet you go through and you look at how they did stuff. Like in this case, he doesn't do the HGN correctly. He doesn't instruct about even starting too soon. One that is, I think, a great one to utilize on the field test is just you lose balance, right? That sounds horrible when you hear it, right? You hear that as a person, you're thinking they're losing balance, they can't stand up. And yet all that means under the criteria is they break that heel to toe stance and go back to a normal everyday stance. And that's just a demonstration of how that unfairness can really impact on how they're perceiving it, how they're analyzing it. And then you have to then somehow find a way to show what the field looked like, what their operation looked like to the test. And Don and I were talking about the test earlier. And what's weird to me, I'll be honest with you, is we don't see a lot of, I'm a single column blood alcohol analysis on a GCFID. We don't have the mass spec. We do duplicate analysis at the same time, and that's it. But in this case, you have the mass spec, and then you have like a replicate testing like 3 or 4 days later, I think. And then it looks like there's probably an independent testing from the facts. The problem is one, you need the logs. You got to have all that information to try and determine what's missing. Did they do things right? Why is there, what's their retention times? What's their separation matrix? How are they checking for things that can contaminate or lead to coelution or any other problems? Because the mass spec doesn't look like it quantifies, I don't really care about the mass spec. I just want to care about the GC and the quantification and why the quantification is off. And so in talking at that, we started looking at just something as simple as, if this is the client's analysis on the first day, it's showing methanol, acetone, I can't remember if isopropanol was in there, and yet on the test a couple days later, it's not showing any of those other substances. So what happened to this? Why is this substance, or why is this sample reliable? Has it been contaminated in the first one? Are they checking the second one correctly, or did somehow the vials get mixed up? How do we know this is the one that went to our client? And when you start seeing conflicts in those things, when things don't match up, they call into questions. That's all we're trying to do is say, look, if this is a question, if this is a problem, if they can't explain it, just throw it out and then let's look at the video. How about you go on from there, Don? I know we talked about some other stuff.
Sure. I looked at this case and I think it's a classic disconnect case. You have a little bit of weaving, but the driver on the video says that at the time of the weaving, he was checking his phone or something to that effect. But the field sobriety tests, the driver does very good on those. I wouldn't really attack them tremendously. I would set up that if you look at the video, this guy sounds and looks sober, but the blood tests suggest he's twice the legal limit practically. I then took a look at the blood test. In my opinion, you have to be very simple and offer maybe 2 to 3 criticisms at most of a blood test. Too many and you lose them in the science. I would set up the reasonable doubt and why you would want to doubt the results of the test are fairly obvious. First off, these tests require duplicate quantitative testing. There was one done on September 14th, and apparently the second test was not done until September 17th. Not sure why there's a delay there, but my first criticism would be that the officer said they only inverted the blood tube 5 times. And I believe that Becton Dixon, the maker of the tube, would say that you have to invert it at least 8 times. I would leave that out there. I would, in my closing argument, I would say here are the reasonable doubts. They didn't mix the preservative and anticoagulant sufficiently. There is the presence of methanol and acetone in the first test, and it's absent in the second test. There's a change in the size of the area peaks that's unexplained between these 2 tests. And frankly, I would be critical of the test results because they seem to have used the same column for both tests, and science would, and so the order of elution is what it's called, remained the same between test 1 and test 2. That's not what science recommends if you're able to bring that out. Additionally, on the September 17th second test, there's some unidentified peaks in the chromatogram that, if you were to compare them with the first test, do suggest that there is some other volatiles that are in the blood that go unexplained. I would get to the closing argument, and I would tell the jury that they should find that the state has failed to prove the case beyond a reasonable doubt because there are unanswered questions. And the unanswered questions are, what are these peaks in the second test? Why was this only inverted 5 times? Why is it that the defendant in this case needed to be tested twice in 2 days when it should have been done right away? I would think that's your basic argument here. If you tell the jury they can believe their eyes or they can believe these diagrams. But most interestingly, I would highlight exactly what the report from TBI, Tennessee Bureau of Investigation, says. When they reported the result, it says right below the analyst's signature, it says the 0.151, the above represents the interpretations and opinions of the analyst. So in my, I would suggest that science is not an opinion. Science is a fact. But what they're offering the jury is an opinion and an interpretation. Without that explanation, this would be how I would treat the case and how I would close it.
I'd like to follow up with 3 points. Bill and Don had made some great points. Number one is my theme would be this is a rush to judgment. And I would pick the jury on, do you believe more what you see or versus what you hear? And that's how you set up the disconnect defenses, is Don enumerated, because you're going to say they're trying, in closing argument, they're trying to convict your client with not with what you see, but only solely what you're hearing. Because what we're seeing is, and then you're pointing out to the visual evidence that demonstrates sobriety, and they're only trying to convict with things that they hear. Bill made an interesting point, is the officers are always basically, you know, in my jurisdiction, I always hear based upon the totality of the circumstances. And it almost makes you puke every time you hear it, because you know it's complete nonsense. Because what they do is they cherry pick certain things to support their conclusion. They don't rely upon the totality, because the totality in this particular case would demonstrate sobriety. And there's so many good things to utilize. The last point I want to make is it appears, and I don't know this for a fact, but it appears there was an independent blood test done on this particular case. And I know that there are varying views, but I'm just going to give you Doug Murphy's point of view on this. And that is, I would never, ever independently retest blood unless I believed it was, 1, not our client's blood, or 2, we were right at or near the legal limit and we thought it might come back lower, or some other reason to suggest that there might be contamination or some other bona fide reason other than just a blanket, I want to retest just to see if it comes back lower. Because what happens when you do that is, in our state, the state has a right to what those results are. And then the state can basically close the door on all reasonable doubt that you're going to raise with a lack of reliability and accuracy in following standard operating procedures. And anything that you're highlighting that's wrong with the blood test, you can undo by independently testing it. So I would be very cautious in retesting blood. And those are my takes.
And just along that line with the retest, I agree with you. I think we can only harm ourselves. So if I ever want to retest because there's some other potential issue, I'm looking for, did they have the right preservatives in it? Did they have something that I can then bring to the jury to say why this test is disregarded, is being disregarded? I would never retest for alcohol level.
Well, thank you very much. I certainly appreciate that analysis. And for those of you who are not members of the National College for DUI Defense, I'm going to give Doug just a few seconds here to tell you about the college. And I think you can see from the expertise that you're hearing already that there is a lot of science in DUI defense. And that's one of the things that we focus on in addition to the theories of defense and the law. But Doug, I'll let you take it from there. And then I'd like to add one comment before we leave.
Okay. Thank you, Steve. Yeah, if you're not a member of the National College for DUI Defense, we would encourage you to join, as the benefits will substantially benefit you in your practice. You can join by going to ncd.com. Number one, we have a robust listserv. There's a bunch of great experts and veteran lawyers on there who constantly monitor and help each other and help lawyers with not just legal issues, but scientific issues as it relates to DWI defense. Number two, we have a robust slate of seminars that we put on every year. For instance, in January, we're putting on January 15th and 16th in Houston, Texas, putting on a trying serious bodily injury and DWI death cases over the course of a day and a half. We'll have some of the best speakers in the country about trying these cases and on how to do that. In March, we hold the Mastering Scientific Evidence seminar that is done with a full day of lecturing and then a full day of mock trial. It's one of the best seminars in the country that really helps dive deep into the scientific evidence of DUI cases. And then in July, we have our Bellwether seminar. That's our summer session that's conducted. This next year will be the 26th year at Harvard Law School. And that's 2.5 days of intensive really the anatomy of a DWI trial. And then generally late September, October, we have the great DWI seminar that's done in conjunction with the National Association of Criminal Defense Lawyers that Steve is always the course director on, does an outstanding job. It's 2.5 days of very intensive, all over the board, great topics on DWI defense. And above all that, there's great camaraderie amongst all of our members, and we not just have the camaraderie, but that camaraderie helps teach you and build relationships for advice and mentoring. And we'd encourage you to join. Thank you, Steve.
You're welcome. And I'll just add, for those of you who are unfamiliar with Tennessee law on horizontal gaze nystagmus, I have put in the meeting chat the citation for State versus Cora Murphy, which is our leading case in Tennessee, indicating and holding that in order to admit the HGN results, the results must be introduced by an expert, not just a police officer, but somebody with more scientific, technical, or other specialized knowledge. So I put a little quote in there, and we're going to move on to the next portion, our next problem. And that is going to be led by David Katz. So David, I'm going to let you take it from here.
Thank you, Steve, and welcome everybody. So in the next problem, the stop is based solely on speeding, 18 miles an hour over the speed limit. After the officer indicates that he wants him to stop, lights up the car pulls over with no problems at all indicated in the report. The officer states that he smells alcohol, notices slurred speech and bloodshot glassy eyes, and based on that asks the driver to do field sobriety. In Florida, we call them exercises. So if you hear me use the term field sobriety exercises, I'm talking about the tests that you all refer to. but asks the person to do the field tests. The person agrees, gets out of the car with no problems at all indicated. On the HGN, the officer observes 6 out of 6 clues and does not make any notation as to whether or not the driver followed directions, moved his head, or swayed while standing. So I think you can safely use that as something your client did right, since it doesn't say that they did that wrong. On the walk and turn, there were 2 indicators seen. The person lost their balance while walking. It does not indicate how many times. And also lost their balance while making the turn or turned incorrectly. That's all that's indicated. And so they then asked them to do the one-leg stand, and on the one-leg stand, the officer observed no indicators of impairment. After that, the officer asked the person to take a preliminary breath test. We did a little research, and in Michigan, a preliminary breath test is not admissible, but the results of the preliminary breath test was a 0.14. The officer made the arrest and asked the driver to provide blood, because at the time, all of the breath tests, all the evidentiary breath test units in the state had stopped being used because of issues with their calibration. Apparently, about 6 days after this arrest, they all went back online. But in this case, they took a blood test. We have no blood discovery or results at this point, so we don't know what that blood draw result will be. For purpose of discussion at the moment, I'll assume that it was in line with the preliminary breath test. And that's all the evidence in the case. So to me, this sounds like a great case for using what at the college we call the real FSE defense, breaking down everything that your client did right from the moment the officer saw them. As most of you are probably aware, speed is not an indication of impairment. During the stop of the vehicle, there were no indications of impairment displayed. And if you break down every step of this encounter, starting with the driving, and talk about all of the different indicators the officer could have seen, and yet what he saw was speeding, which doesn't indicate impairment. On the stop, there's another 7 indicators the officer could have seen in his training. He saw none of those. When he approached the person, there were no physical manifestations of impairment. The driver had no problem getting his license from his wallet, or producing it, or opening windows, or lowering the radio. There's just no physical indications of impairment at all here. And so I'm not going to go over everything. I'm going to turn it over for Steve and Ginny to add some comments, and then I guess I'll come back at the end maybe. But this is just a perfect case, at least up until the chemical tests, for that real field sobriety exercise defense.
Hi, Steve Hernandez here. I have to agree with Mr. Katz with regards to the real SFSTs. I like to break it down at the speed, starting with the speed. Again, as David said, speeding is not an indicator of impaired driving, but it also shows maybe the ability to control your vehicle. Driving at a high rate of speed takes a little more skill, especially at night. Going to that, with regards to the contact, I know that in many states you're required to produce not only your driver's license, but your insurance and your registration card. If you're required to do that in Michigan, where were those documents located? Was he able to get the license from his wallet? Clearly he was, because it would have said so in the narrative. But he was also able to get his other credentials, his registration and insurance. He was able to get 3 documents from probably 2 separate locations. Shows kind of a coherence here, his ability to get to follow instructions. He had no difficulty pulling over. He pulled over, I assume, because that would have been in the report. He spoke to the officer. He followed the officer's instructions, rolled down the window, got out of the car, didn't fall out of the car, didn't stumble, followed the officer to where he was asked to do the field sobriety tests. Again, didn't stumble as he walked, didn't stumble as he stood. Followed those instructions clearly. Did those field sobriety tests. As we said, the walk and turning, he showed two indicators, but we don't know what the real deficiencies were. How many times did he step off the line? Was it one time? Was it 3 times? It's something very important to know, but more important, and I know you have an MVR in this case, but more importantly, there's 9 steps forward, 9 steps back. If he stepped off the line 1 time, that means he stayed on the line 17 times. And you can break that down for everything. He kept his heel to toe on 18 steps. He stayed on the line for 17 steps. He kept his hand to the side for 18 steps, etc. So you could break that down. And most importantly, he passed the one-leg stand. And as we know from training, I think I just.
It's still working, Steve. Everyone can hear you.
I'm sorry.
Yeah, just keep going.
That when someone keeps their leg up for 26 of those 30 seconds, that's a pretty good indicator of sobriety there. The one-leg stand is a very hard test to keep your leg up that long. With regards to the blood draw, I see the blood draw was done at the local jail by a nurse. However, how sanitary was that jail? It was not done in a sterile environment. And that's about it.
Steve, can you hear me?
Yeah, I can hear you.
So why don't you explain why the one-leg stand is so important compared to, for instance, the walk and turn?
Well, I don't like to play the percentages game, 68%, 67%, but I'm having trouble here, guys.
Well, certainly under the most recent studies, the one-leg stand has been determined to be the most accurate of the 2 physical field sobriety tests. And that's why I think it's probably important to stress that. Yes. Virginia, why don't you take it from here?
Okay, so first I want to say thanks to Steve Oberman and thanks to NACDL and thanks to all you guys that are actually on this call trying to learn something. So there's been a lot of information that's already been given to us about the facts on this particular thing and how that helps you to develop these issues. But you got to understand right now in today's world, we got to be masked up. We have to engage people in a completely different way. So if we're talking about all the wonderful things that this guy did correctly, you have to animate it. You have to make it be larger than life. You have to make all of those things come back to you in a very practical and a very easy way for the jurors to understand what's going on. So if we're talking about the 3 primary areas, we've got the driving, we've got the symptoms, and we have the toxicology. So I'm a big believer in 3s. You've heard us talk about that at the college an awful lot. Your facts are going to drive what you decide to. Quick facts. He's driving really well. He's speeding. In California, it's kind of a prerequisite. If you're not in a hurry to get to where you need to be, people don't understand what's happening. So you've got to break that down into all the different parts of what an individual did correctly. And don't minimize all of the other things that NHTSA puts out in their studies about indicators for police officers to say, this is a reason why we should stop somebody. And he had one thing, and speeding is not one of those indicators. How does that transition into the standardized field sobriety test? The symptomology that goes on when you're talking about that next stage, getting somebody out of the car, talking to them further, making them do these hand, eye, gait, coordination exercises on the side of the road with cars whizzing by you. And in our fact pattern, it was icy out. The state of Michigan is our fact pattern. So what you have to look at for things like that is how can somebody do 100% on a test that has both the mental and the physical dexterity that they have to check on an unideal condition, with obviously something that is going to be very distressful for the individual on the side of the road going through those things. Sometimes I think we get so wrapped up in all of the facts and hitting the science and doing all these other kind of things. And you've got to understand, you have to have engagement right now. And when I mean engagement, I mean, how do you make it real? How do you make it? Have you ever seen somebody on the side of the road that's been pulled over and you wonder, I wonder what that guy did? Or as they're going through field sobriety test and you see somebody that's doing certain things, how do you go and demonstrate physically in front of the jurors or in front of the judges and show them what is good about your case? Now, look, our case, we had some really good facts about field sobriety tests. So we're going to spend a lot of time going through those because that's going to help the issues. If you don't have good facts about that, of course, you're not going to spend a lot of time on that. You're going to come up with something else. But if you're not engaging with the people that are making the decision on the case, it's going to be a problem. So here's the thing. What do you do when you're masked up? Many jurisdictions have already opened. We have things that are being done virtually over team meetings. We have trials that are happening over team meetings. I'm not going to do that. No judge has forced me to do that yet, but it is happening in California. And if you don't think that that is a problem for the person who is accused, then I think you need to get your in limine motions up quite a bit, because you need to be able to show it is maybe not even appropriate right now. If you've got a client who's elderly, if you have a client that has medical issues, if you have other things, those are not things that are going to be listed within the police report. Not necessarily. Are you under the care of a doctor? Yes, I am. Have you had surgery? No, I haven't recently. But that doesn't mean that they don't have underlying conditions. And if you're putting somebody at risk just by being in a court scenario, that's something you also need to look at now. So pound them on those motions to suppress. Pound them on the in limine motions to try to exclude certain things. But you need to become engaging. If you've got a client doing 100% on that test, do not gloss over the one-leg stand. You have got to break it down in each part. You have to talk about how that's a physical condition. You have to talk about how the client physically did it. You have to talk about the mental lack of impairment. You have to talk about each thing that that person is required to do in order to make that happen. Your roadmap should be what's good about your client. It should never be a factor that is going to bring extra attention to something that your client didn't do correct. Now, that's kind of elementary from a perspective. But if you can't stimulate their brain to think, the trier of fact, if you can't get them to think about a situation that they've been in that is very similar, or the kid that's playing ball in the field, and yeah, maybe he let one of them go through his legs, the Billy Buckner defense, okay? But what happens there is that person remembers that activity. They remember if they felt bad. They remember if they caused that losing, play on the field. What you have to do is reach out to those triers of fact so that you have the capability to make it real. Because then when you're doing a disconnect, we have these great field sobriety tests, and we have a 0.14 as a reference point. It's just that, a reference point. Take it apart by the practical things, by the reality of what is going on. The fact analysis by the police officer just gives you a roadmap. You fill in the facts that they did correctly so that you can make it work for you and your client. Now, be careful. You can't see if I'm smiling as I go through this stuff. I can tell you right now, I am laughing, I'm smiling. You can't tell that masked up. So think about if you're being required to be in court and to do things. Our courts allow us to do these masks. They also allow us to do the shields that are over your face. So I have gone ahead and made it for motions that we have, and my first trial is scheduled for the end of the month, and I don't want to be in court doing that. I can candidly say we have not fully reopened. So if we're going to do trials, we have to be able to see people. You can't get that full evaluation. You can't get that full overview if you can't tell what the witness is saying or what their demeanor is like behind their shield. Okay, so think outside the box. Don't just look at what happens in the police report. Look at what you can review from the police report and make practical, important, and showing no impairment by your own analysis, and make it engaging.
Virginia. All right. By the way, I'll just remind you, if you do have questions on your screen near the bottom, there is a toolbar with a little hand that if you press that, we'll be able to see that you have a question and try to get that answered, or you can type your question in the meeting chat and I will monitor that as we go on. So I think now it's appropriate to go to our next team and their problem. Bruce Edge, another regent on the board of regents with the National College for DUI Defense, will be leading this discussion. So Bruce, I'll let you take it from here. And it will help if you turn on your microphone, Bruce.
Sorry, Steve, it was Paul, and I just wanted to remind folks to mute themselves because we're getting background noise.
Okay. Thank you, Steve, and thank you, Virginia. I really like that reminder that we're speaking to the jury as people, not as some cold, hard, factual recitation, and I think that's very important for us to remember. Today, we're looking at a case out of Iowa. It involves an individual that made an illegal left turn, according to the officer. What it amounts to is they were making a left turn. They cut short as they were cutting, and they went a little bit across the turn lane and touched the yellow line as they were getting into the lane. That was the traffic violation. Beyond that, the police report has a standard verbiage of everything bad the client did. The basics are, she scored 6 out of 6 on HGN, admitted to having a pint of beer, admitted to taking gabardine, which is for cerebral palsy. She refused a PBT, refused the breath test. The police report clearly indicates it was unable to perform the walk and turn and the one-leg stand due to the cerebral palsy. And there is an expert that will say in clinical trials that the drug she's taking could cause a display of HGN. The cop also claimed there was VGN. The expert will say they know of no clinical data that would support that opinion. The charge was submitted under 3 theories: that was under the influence of drugs or alcohol, was under alcohol with concentration of 0.8 or more, or the third one was any amount of controlled substance present in the person's as measured by the person's blood or urine. Right off the bat, I would see problems with the charging instrument. They're saying that according to the wording of the charge, that any drugs would have to be determined by measurement of the person's blood or urine. They don't have a blood or urine test. I would also not go after the 0.08, but I would look at the total thing that's being submitted saying, hey, jury, pick one. We don't know which one it is. Well, that's just such an easy answer to say, they don't know. How are you supposed to know? This is not a guess. It's beyond a reasonable doubt, and they can't even prove one, much less throw 3 at you. There's a number of things that I like the terminology because in the officer's report, he said the defendant's balance was fair and used support. You've heard that, they use support. Use the car for support. Well, heck yeah, she used support. Officer, do you call a cane support? You didn't call it that, though. You didn't leave that in there. And I think that would be, a jury would find that a little bit demeaning to the client, overlooking. It just shows a predisposition to overlook the fairness in the process. There's several things in here we could go through. I'm going to leave some of this for the other people that are speaking, but I would love this part of this case, and I would give a shout out to a fellow of ours, Les Holnick. To me, this is an opinion case. It's strictly the cop's opinion. There are no facts in here to support intoxication other than the cop's opinion. And Les Holnick would set this up in voir dire. And you have to set it in voir dire if it's going to work. But he would stand in front of the jury and he would say something like, ladies and gentlemen, I've got a tie. This tie is yellow. Will you agree with me that it's yellow? He gets agreement, and then that's a fact. The fact is it's yellow. Now, this morning when I was getting dressed, my wife informed me that my opinion was, it looks good with my suit. You don't have to agree with that opinion, do you? Even if you disagree with that opinion, it doesn't change the fact that it's yellow. You get the jury's agreement in there, and then you turn and say, now, if this case goes forward, and the state has a witness strut in here, straight back, full uniform on, badge, patches, sits down, and then tells you his opinion is our client was intoxicated. Will you remember, you don't have to agree with that opinion? You can listen to the facts. That's why you're here, isn't it, ladies and gentlemen? You're here to determine what that opinion is. So they don't get to tell you what your opinion is. You make that determination. That's a very quick view. You've got to make it much more personal and make it more smooth as you're going through it. But the idea is, don't let the officer's opinion come in and carry great weight. And that's what you're going to be dealing with in this case, is an opinion. We'll come back if we need to, but let's see what some of the other guys. I think we've got Paul, who's one of our former dean from last year. Paul?
Yeah. Hi, folks. Nice to be with you. Can you all hear me? You're not hearing me.
We can hear you, Paul.
Oh, okay. Good. Thanks, Bruce, for those comments. First thing I'm looking at this case, based on my research, first offenders in Iowa are eligible for a deferred judgment on DUI cases. This individual would be eligible, but for the refusal allegation. So I'm talking to the prosecutor and judge and see if we can get them to strike the refusal and offer them a deferred judgment on the case. Wouldn't be too hard to make that sale pitch to them. It's a pretty weak case, and you know, if they needed something to hang their hat on, you would look at the code section for their implied consent, 312J.6. Cop has to have reasonable grounds to believe that the person was operating the vehicle under the influence. That's questionable here. So, you know, it'd be something for them to hang their hat on, strike the refusal, get them a deferred judgment on the case. All right, that doesn't work. We're on to dissecting the case and getting it ready for trial. Gabapentin, you know, you need to understand that gabapentin is not just used to reduce anxiety. It's commonly used to reduce the urges to drink. So it can be very prejudicial for a jury to hear that this individual takes gabapentin and has prescribed it, because they know that they're going to jump to the conclusion that the person's an alcoholic and is trying to drink through it. So just something to keep in mind. You want to make it very clear to the jury that gabapentin was prescribed because of the palsy, not because she has a problem with alcohol. And if you need to, bring in the medical record showing the diagnoses and the reason for the prescription. You got to ask yourself, what is the relevance of, if any, of her being or her having been advised that alcohol should not be mixed with gabapentin? Because what the prosecutor's trying to do is say, hey, jury, she knew she wasn't supposed to drink with this medication and she's doing it anyway, ergo she deserves to get the DUI. I would try to keep that statement out in a motion in limine because I don't see any relevance to it. DUI is not a specific intent crime. Whether she knew or didn't know that there may be an impairing side effect from drinking just a little bit of alcohol with the gabapentin doesn't have any relevance. Now, you may want to try to flip that the other way and let them introduce it, and then suggest subtly to the jury that she didn't realize that just one beer would have a side effect, and there's no evidence, in fact, that one beer did have a side effect. Just because there's an admonition or cautionary thing on the prescription that is mixing alcohol with gabapentin could cause an impairing effect doesn't mean that that actually happened. And given the fact that she only had one beer, it probably didn't happen. Let's see, what else did I want to talk to you about? She was playing a game called Bar Trivia at the bar at Donnelly's Pub. Well, that requires some mental faculties working. If you're going to be playing a trivia game, you got to be thinking clearly. And if the witnesses are saying that she was playing bar trivia and she was doing well, that's circumstantial evidence that she had her mental faculties working. And if her mental faculties are working, then her physical capacities were working, because deterioration of the mental faculties precedes the deterioration of the physical abilities. There's one other point I wanted to make. Oh, I was just thinking about trial tactics here and putting the visual in front of the jury. Can you imagine if you saw this individual with cerebral palsy walking down the street and they had a beer in their hand? You would assume that that's a drunk. And here, that's what this officer did. He saw poor balance. She made an admission of drinking, and he assumes that she's an alcoholic. And that assumption, sadly and inappropriately, was based on a medical condition. So that's where I'd be going with this case. There's just a few thoughts for you. Thank you.
All right, well, thank you very much. Is Lauren on the call as well?
Yes, I'm here.
Lauren, we'd love to hear from you.
Okay. So kind of just going off what both Bruce and Paul said, I really think anytime you have a case like this that involves, one, an underlying medical condition, and two, some sort of medication with no ultimate breath or blood test result, it really gives you an excellent opportunity to reframe the case and puts you more on the offense as opposed to the defense, which is where we normally are. There's very arguably a clear explanation for the impairment by way of solely the cerebral palsy. And I'm not even talking about any potential effects of the gabapentin that's being taken. That has its own potential, central nervous system depressant effects. But just alone, someone with cerebral palsy, as Paul was saying, and I know there's a spectrum, this individual, she used a cane, but that's a disorder that affects, it affects movement, it affects sometimes speech, it affects muscle tone. So there's certainly the argument that alone could have been the explanation for any initial observation of impairment. As far as the driving goes, it seems like a pretty minor traffic violations, something that probably occurs pretty often, just making a turn a little wide one way and crossing the line where there's no oncoming or traffic next to it, making it a danger. And then there's contact with her, and we have these observed observations, and we were given some additional information from who submitted this case saying, I'm assuming there was a recording that we hadn't received, but it appears that in the recording there really wasn't slurred speech or droopy eyes, and she appeared to be, you know, relatively steady in that regard. But, you know, when there's issues with the HGN, and I know Attorney Oberman was talking about how you can get that out, and there's ways that you can get that out in a lot of cases. I always like to have the horizontal gaze nystagmus test in a case, because very rarely does a law enforcement officer actually administer that appropriately. And let's say that, give the officer the benefit of the doubt here, he performed it perfectly with no problems. Her alone being someone who suffers from cerebral palsy, you know, it's a muscular disorder. There's certainly muscles in the eyes. That automatically, I think you can would make her a bad candidate for that, in addition to the one leg stand and the walk and turn, which the officer correctly didn't perform. And moreover, the complaint or the charging document said they were going to, the criminologist, the state's witness, is going to talk about the effects of alcohol combined with gabapentin. To do that without any test result is absurd, because they're not going on anything actually factual. And second, this individual has absolutely zero knowledge of this person's particular tolerance to gabapentin, if they're going to take that route and try and charge it, you know, based on the drugs and alcohol combination. And moreover, has no specifics about her physiology as it relates to her disorder. So overall, and I do think if there was a test result that showed, you know, levels over not in line with her prescription, and potentially also a test result showing alcohol over the legal limit, it's a different ballgame. But with no test result and facts like these, I think it really, it's that special scenario where it puts the defense in the offense position, because their ability to prove, you know, impairment due to alleged drug and alcohol without a test result, and with the combination of what seems to be a prescribed medication for a disorder that exhibits signs of impairment at times, I really think it does put the defense and the offense in that position. So great trial case.
Well, thank you very much for your comments, Lauren. Those are insightful. And we're going to move on to our final problem. So, John Hunsucker, do you want to take over from here and tell us a little bit about your problem?
Okay, well, actually, I think Joe's our team leader, but
Okay.
I'll do it once, I'll do it, but.
Well, we don't want to make Joe mad, that's for sure.
Go ahead, Joe.
First, I wanted to say greetings to everyone from Tucson. You can certainly tell that it's fall because it's only going to be 96 degrees here today. I am working with John Hunsucker. John is from Oklahoma City. He has written about 20 books on DUI. We also have James Phillips from Florida, who's going to be working with us on our team today. James is board certified in DUI defense. That is something that the National College for DUI Defense offers. We have a board certification test. The next one that we're giving is going to be about a year from now at our Las Vegas seminar, that the good Lord willing and the creek don't rise will be in person. It is recognized by the American Bar Association. We're the only organization that is recognized and able to get board certification that is recognized by the American Bar Association. So for our problem, we're going to be talking through what happens and what you do in examining issues and investigating a case when the client first walks in the door. So a client comes in and he brings you his citations. He has 3 charges, one of which is driving under the influence. The second is disregarding a traffic control device, and the third is improper lane usage. This occurs out in Chicago, Rosemont, Illinois, I guess, and it is not far from O'Hare International Airport. There is a casino, just I think a mile or so away from the airport. Unfortunately for our client, about a block behind the casino is a police station. So the client tells us that he has left the casino, made a U-turn and made a U-turn to his right at the intersection or meeting of the streets where this happens. There was a no left turn sign, and that he was pulled over because the officer believed that he had violated the no left turn traffic control device by making a U-turn to his right. Officer smells alcohol. Officer requests client to take a breath test. When client attempts to do so, he begins coughing vehemently. Ultimately, an ambulance is called, and he is taken to the hospital. He is unable to produce a breath test because of what is diagnosed at the hospital as a lung infection. On the way to the hospital, the paramedic got blood from him and tell him, hey, you're not getting out of this thing because you're having problems with your breath. Now we've got your blood. Gets to the hospital, receives a diagnosis. Client states that he is asked to take a breath test at the hospital again, can't do so. Asked to take a blood test or asked to provide a blood sample, says, no, I don't want to, and so is charged with DUI. So I guess the first issues we want to talk about relate to the driving and the stop. James, did you want to weigh in on that?
Yeah, thanks, Joe. I think this is a great case. The facts are definitely in our client's favor. In Florida, the prosecutors always want to talk about the totality of the circumstances. So in this case, I would actually flip this switch on them. And I'd say, listen, I agree with that. This case is about the totality of the circumstances. And I'd really break down all the opportunities this officer had to observe indicators of impairment and point out all the indicators of sobriety that the officer missed. And I would start, with the first phase of the DUI investigation while the vehicle's in motion. I'd make sure to get out how long this officer was behind him and the fact that he didn't observe any kind of erratic driving pattern except for this illegal turn, which in itself is questionable. This would definitely warrant a motion to suppress to contest the validity of the stop before trial. But looking at all the indicators this officer could observe while the vehicle was in motion, all he saw was what he terms a illegal U-turn. I would take that U-turn and actually turn it to our client's advantage and talk about how he was able to show good judgment. He was able to make this U-turn without affecting other traffic. He was able to determine the amount of space he needed to successfully manage the U-turn. He didn't strike the inside curb, so he was able to adjust the distance to make it. He was able to adjust the distance to make it all the way around on the turn and not strike this outside curb. We've all seen people who make a U-turn, they misjudge it, and they end up having to throw their car in reverse to back up to successfully maneuver. I would point out all of these are actually indicators of sobriety and really beat it to the jury that, listen, based on the totality that the state wants you to judge this case on, we need to look at all the totality and look at all the indicators of sobriety, the driving. After the officer initiated the traffic stop, this was an opportunity for the officer to observe other indicators of impairment, and he observed 0 of them. And I would break down and go through each of those and point out that the client showed nothing but indicators of sobriety and go all the way through. Even when he made contact with the client at the side of the road, he only noticed the odor of alcohol coming from his person. Well, that can be explained. Being at a casino, someone could have spilled beer on him or some kind of liquor. And he noticed that his eyes were bloodshot. And that was it. Again, the guy's leaving a casino full of smoke. We also know that he has a severe lung infection, which obviously probably caused him to cough a lot and almost, hack up the lung. So I think we got great things that we can show based on the totality of the circumstances from the driving on, nothing but signs of sobriety coming from him. So yeah, we need to, first of all, drive out to the scene. The attorney doing it needs to go out there and observe, because beforehand we went on to Google Maps and tried to map out and try and find this sign, and we weren't really able to find it. We found a turn only on left turn signal only signs, but that's it. So the attorney needs to go out there and really observe to see if this sign is actually even out there. Contest the stop. If the state survives the stop motion, then attack in jury trial the whole totality of the circumstances showing nothing but sobriety.
So John, let's say that it is, as James described, turns out to be not a no U-turn sign, but a turn left on, green light only, and the client does a driving behavior, makes a turn to the right, a U-turn to the right, and the state's position when you file your motion is, well, you know what, it doesn't really matter if it wasn't technically a violation of that sign, because the officer believed in good faith that what he had witnessed was a traffic violation.
Well, yeah, Joe, I think that's a good point. When you go back and you look at some of the case law, like Heinen versus North Carolina, I believe is the case, it talks about good faith by the officer, but that's talking good faith when a statute has changed, not necessarily when the current law is still in effect. I think it's going to depend on your state law. In Oklahoma, that's not going to matter. The judge is going to look at, was it a violation, was it not? These are police officers. This is in their jurisdiction. They should know what their signs say and what the signs say. How do you expect the client to follow the law if the officer doesn't even know what the law is at that point, or whether there's a sign there? And so that argument wouldn't work in Oklahoma. I think it's going to be very dependent on state law. But let's back up a little bit. And in this case, we got some limited information, but this case starts, as far as your representation, the moment that client walks in. First thing I'm going to do is I'm going to issue a subpoena ducis tecum for videos. I want to see if there's a video inside that casino. Let's see what he looks like. When we talk about indicia of intoxication or whether or not he's sober and signs of sobriety, the video is great. So I'm going to issue a subpoena ducis tecum for a casino video, and of course any officers' videos that are available, as well as police reports, any medical records. We deal with a lot of stuff here. If he's got a severe lung infection, was he fatigued? That would cause him to be slow or be lethargic, cause him to have red eyes possibly. And so there's a lot of stuff initially you're going to want to get in this case to be able to prepare a defense on it. Let me show the notes. The other thing I would want to look at is, even though he denied blood, he asked for blood, he refused. Why didn't the officer get a warrant for blood? And that's something that, was there enough time to do that? They were at the hospital, so it would have been easy to do. Do they not have it's Chicago, surely they have a judge on duty where they can get a warrant. And I'd bring that up and use that, it's the officer's job to collect the evidence and prepare it and present it to the trier of fact. In this case, he failed.
Okay, well, let's move on to, I guess, the second issue in the case. We have the officer at the scene saying, I would like a breath test. The client saying, sure, I'll give you a breath sample. And, he's going to say physically unable to do so. God only knows what law enforcement will say. It seems like anytime my clients say something bad, like I had 4 drinks, that's the gospel truth. If they say I can't produce a breath sample because of my lung problems, then that's very suspect and shouldn't be taken at face value. But here we have some medical documentation. We've got somebody with a genuine problem who doesn't seem to be able to produce a breath sample. In Arizona, anyway, and you guys will tell us in your states if it's the same case, If you're asked to produce a breath sample and you fail to do so, that can be used as in court. That can be introduced against you. And the trier of fact is instructed that they can take it as evidence of consciousness of guilt, that you're not completing a test because you know that if you did so, it would hurt you, and they can hold that against you. Does that apply in this case, James?
Yeah, I would definitely fight it. I'd file a motion limine or a motion to suppress, and I would contest that this was not a lawful refusal. You may need to bring in a medical expert, something to talk about the kind of infection he had and the repercussions of having it, and whether he would be physically able to, or someone with that condition be physically able to produce a valid breath sample. I would definitely argue, listen, the state may want to say it's consciousness of guilt, but this is someone that actually tried to do it. I would do a motion limine to try and keep them from arguing that, because he did, in fact, try and provide the sample and was just physically unable to. So if we look at his conscious, he was trying to agree with taking it. So I would fight that.
Joe, I would add to that I would also go into the fact, at this point you're at trial and they haven't done anything with the medical test from EMS. At that point, I think there's a legitimate argument in front of the trier of fact or in front of the jury that, he was told they already took blood. They said, the paramedic said, we got you now. You're not getting out of this. And so in his mind, he's already given blood. Why would give another sample at that point? And so I would use that and turn that around against the prosecution. And also at that point, the jury's sitting there going, well, why didn't you bring us that blood test from the EMS? Without even getting into the whole medical tests are different than our forensic tests.
The other thing I was thinking about on this is all breath testers, the breath test evidence is based on the assumption and belief that you're going to get a good, clean sample of the alcohol that's in the person's lungs. And towards the bottom of the lungs, the alveolar area at the very bottom of the lungs is really what they are striving for, because that is supposed to be in concert with how much alcohol is in the blood system, which is affecting the brain. That's the theory behind breath testing. So we have these safeguards in place. A lot of the time we have a period of time when you have to make sure there's nothing that goes in or out of the person's mouth, a deprivation period before they can take the test. In many states, there's a requirement that there be 2 breath tests, 5 to 10 minutes apart. They have to agree within a certain percentage. All of that is to make sure that you're not capturing mouth alcohol. That what you're capturing is the deep lung air. If you've got somebody with a lung infection who's coughing like crazy, you're never going to get an accurate sample. I mean, the machine just isn't built to, get an accurate sample off of that person. He is not a candidate for that breath test. So that's even more of a reason that, his inability to complete the test shouldn't be used against him at trial. So let's move on to the next phase. We've got the EMD, or somebody in the ambulance who decides that he wants to be a police officer, and by God, he is going to get a blood sample from the client. Let's say that the state wants to try to use that against our client. Is that something that's going to be allowed? John, what do you think?
In Oklahoma, they would not allow in a medical test. It wasn't done according to what we call our board of test standards. And so it would not be allowed in Oklahoma. If it was allowed, then there are some ways to attack that with an expert. Most medical tests seem to run 25 to 30% higher than a forensic test. And so it's definitely something we would argue, but it's not an issue we deal with in Oklahoma because it's just not allowed.
How about in Florida, James? James, did we lose you?
Hey, Joe, I'm back. Sorry about that.
That's okay.
So in Florida, medical blood can come in. and then you just have to attack it. Bring in experts, show the difference between medical and legal blood, and like John indicated, how medical blood has a tendency to be about 28, 30% higher. If they're trying to bring in the medical blood, then obviously you need to look at the chain of custody, the procedure that was used by the EMT and the ambulance to obtain it, to make sure there was no kind of contamination issues to bring up. So that's how I would attack it.
Yeah. And Joe, I added a site real quick for an article I read this morning when we're dealing with not having the ability to blow into a breathalyzer. I think I got the site right. If you just Google the title, it'll come up, but it's Alcohol Breath Testing in Patients with Respiratory Disease by M.J. Morris. It's been cited in several articles. It's a decent little read on breath volume and the ability to actually blow into an intoxilizer and get a test.
The other issue I was thinking about is, by statute, we have a medical blood draw exception in Arizona. It's pretty well been eliminated by case law, but in Arizona, there would be a distinction between blood that's drawn for medical purposes that the police then go on and get. And these days, you're going to see a warrant for some of the blood that has already been drawn from the client versus blood that's taken for police purposes. And if you have the people in the ambulance and can demonstrate that they took it because they were going to help out the police and make sure that they had some blood that they were able to test, that's not going to comply with the medical blood draw exception. Okay.
Joe, I believe you have a question there. Let's see if we can get that answered.
No, he was asking about the article, and then he saw that I'd posted the name of it.
Oh, okay. Thank you.
All right. So question answered. Mission accomplished. All right. And our last issue is, as John says, is we've got the guy at the hospital room. The client is at least telling us that he was asked to take a breath test there. Between the three of us, I'll tell you candidly, we don't think that could be anything other than a preliminary breath test. No hospital we know of has any breath testing equipment in it. But the client is asked to give a blood test at that point, has sort of had it and says, no, enough is enough. What can we do with the fact that they don't go forward and get a warrant, as John was talking about a little bit earlier? Don't get a warrant, don't draw his blood. I would say, 150 times out of 100, that's what they're doing in my cases. Can't imagine why they wouldn't. James, what would you try to do with that?
If they don't obtain a warrant to try and get it, I would argue going towards reasonable doubt, the lack of evidence. They had the opportunity to get it. They chose not to. And they just want to sit here and try and convince you that, this is a guy who's not cooperating. He was already told by the EMT, kind of like John said, that they've already took it. They had it. Why didn't they do it? That's how I would attack any issues with them trying to say, not show or disclose or get a warrant for the blood.
I mean, it's almost a bad faith argument at that point. There's just no more convenient way to get blood than somebody who's already laying there in a hospital. It's not an issue. Any closing thoughts for us, John?
Well, I like, following that same train of thought, one of the things I really love to do is to use the field sobriety manuals against them. Even in cases where there's no field sobriety test, when you look at it, it's DUI detection and field sobriety testing. And so even if they didn't do field sobriety test, everything they're getting up there and saying based on my training and experience is coming off that manual. And so I'd go back to the manual and have them point out the part where it teaches them that it's their job to go out there and collect the evidence and come to court and present that evidence to the jury. So why didn't you get a warrant to collect that evidence? And I love to use the manual against them. It's great stuff. They really hate it, but it's a wealth of information. If you've not taken the field sobriety course, you need to be trained. I know the college is offering it now several times a year. It's definitely worth doing. If you're going to do this, might as well have the same training that the officer has if you're going to be effective in the courtroom. So.
I think with that, we'll turn it back over to you, Steve.
Well, thank you very much. And I want to thank everybody who participated by listening, and in particular to those who participated by teaching others. There's just so much to learn about DUI defense, and I hope the NACDL members will consider joining the college. If you have questions, feel free to contact me or Doug Murphy or any of the other speakers that you heard from today. I hope everyone has enjoyed this series that's been sponsored by the National College for DUI Defense in conjunction with the National Association for Criminal Defense Lawyers. And it looks like we're going to have another little talk maybe from NACDL.
Sure. Thank you so much, Steve, and thank you to everyone who joined today, both the speakers and the listeners. This has been a wonderful series, and we're so excited that we were able to do this. All of these sessions are available for viewing on the Engage and Exchange webpage, where you can also register for upcoming discussions. I've posted the link in the chat, and I also posted some information about next week's 2020 Presidential Summit and Symposium on Sentencing taking place virtually. It is free. And I also posted a link to learn more about NACDL membership benefits. So we hope that everyone will look at that. And thank you all so much.